Friends, welcome. Chasing History. Stories Behind Lost Legends has a gift for finding the stories we collectively agreed to look away from and then looking directly at them anyway. In the shadowy depths of 1692, the small village of Salem, Massachusetts, became a crucible for fear, suspicion, and injustice. What began as a seemingly innocuous bout of hysteria spiraled into a tragic tableau of accusations, betrayals, and executions that would forever alter the fabric of American society and its legal landscape. The specter of the witch trials lingers still, a dark reminder of the power of mob mentality and the fragility of justice. As spectral evidence clouded reason and innocent lives were extinguished in the name of righteousness, families were torn apart and communities fractured. The echoes of these trials resonate through the ages, raising unsettling questions about the ethical boundaries of law and the consequences of unchecked power. What happens when fear overrides reason? How do the scars of injustice shape a society's legal principles and moral compass? In this exploration of the Salem Witch Trials, we delve into the haunting aftermath for those who were condemned and the generations that followed. We will unravel the myths surrounding this dark chapter in American history, shedding light on the profound and lasting impact these trials have had on our legal system, and the chilling reminders they provide about the depths of human folly. Join us as we navigate the fog of history and confront the uncomfortable truths that continue to resonate in our modern world. The Salem Witch Trials, the original reality show where paranoia took center stage and everyone suddenly became an expert in demonology. Between February 1692 and May 1693, the quaint little village of Salem, Massachusetts, transformed into the epicenter of a witch-hunting frenzy that would put modern-day drama queens to shame. With a mere flick of a finger and a dash of hysteria, neighbors became accusers, and the gallows became the hottest ticket in town. What kicked off this macabre spectacle? A group of young girls, perhaps bored with the lack of new books to read or tired of chores, began exhibiting bizarre behaviors. Think less, dance like nobody's watching, and more, screaming like the devil is literally chasing them. Before you could say spectral evidence, the Puritan community was on high alert, fueled by a potent cocktail of superstition and a healthy dose of "what will the neighbors think?" The court of Oyer and Terminer took the stage, serving up a judicial farce in which logic took a back seat. With evidence as solid as a ghost's handshake, spectral sightings, bizarre fits, and confessions obtained under a lot of peer pressure, the trials were a legal circus. 20 innocent souls, mostly women, met their untimely demise, proving that sometimes the only thing scarier than witches is a mob armed with a worn Bible and an insatiable thirst for drama. But there were others. Salem wasn't the only town on the witch-hunting bandwagon. No, indeed. Other communities were also getting in on the act. When it comes to witch hunts, Connecticut could easily claim the title of wickedest state, and not just because it has a knack for delivering some seriously tough winters. In fact, the grim reality of Connecticut's witch panic was, in many ways, deadlier than Salem's infamous spectacle. Connecticut's early witch trials were disturbingly efficient. The first 7 out of 9 poor souls indicted for witchcraft were all convicted, yes, you guessed it, resulting in 7 hangings. Over a span of half a century, at least 43 people were dragged into the witch hunt frenzy. A grand total of 11 innocent souls, 9 women and 2 men, met their grim fates, proving that witchcraft accusations had a rather high turnover rate. On May 26, 1647, Alce Young of Windsor became the first person executed for witchcraft in America, swinging from the gallows in Hartford a whopping 45 years before Salem made its debut on the witch-hunting stage. The madness finally began to cool down when Governor John Winthrop Jr. decided enough was enough. He instituted much stricter evidentiary rules. Rumor has it, he even threatened to summon English troops to prevent local magistrates from turning anyone else into another afternoon live action show. Because what's scarier than a witch? A governor with a military backup. The Boston area had its own chilling tales of witchcraft that could make even the bravest Puritan shiver. Enter Margaret Jones, the midwife of Charlestown, who became the first witch to receive a death sentence in the Massachusetts Bay Colony back in 1648. As a local healer, Margaret was the go-to gal for childbirth and other medical mishaps. But in a Puritan society where babies and mothers occasionally met tragic fates, her skills made her a prime suspect. After all, if you're looking for someone to blame, why not the woman who's actually trying to help? Governor John Winthrop documented her case with all the flair of a tabloid journalist. Accusers claimed she had a malignant touch, the kind that could turn your healthy neighbor into a raving lunatic faster than you can say witch hunt. And let's not forget the invisible beings reportedly heard in her prison cell. On June 15, 1648, Margaret was hanged, earning the unfortunate title of the first witch executed in the colony. Fast forward to the 1650s to 1680s, and Boston was getting cozy with its own brand of witchcraft drama. Goody Glover was an Irish Catholic widow who didn't speak English well and practiced her own traditions. Yeah, she was a prime target. When local kids complained of being tormented by invisible spirits, Glover became the scapegoat. After a wash of a court trial, she was hanged, proving once again that outsiders have always been the first to go. Anne Hibbins was a prominent Bostonian and the sister-in-law of Governor Richard Bellingham. She was labeled a witch for being, well, a bit too vocal and argumentative after her husband's death. Apparently, not fitting the meek Puritan mold was a hanging offense. Who knew expressing opinions could be so deadly? The Salem Witch Trials were not just a local blip. They were a nationwide trend where fear and superstition turned neighbors into enemies faster than you can say broomstick. As we unravel the dark threads of this historical tapestry, we'll explore how these tragic events shaped American law and societal norms, ensuring that the ghosts of Salem continue to haunt us, both literally and figuratively. The early American witch trials, particularly the infamous Salem Witch Trials of 1692, were less about actual witchcraft and more about a potent mix of fear, suspicion, and a dash of neighborly rivalry. Picture this, a small, tightly knit community where everyone knows everyone else's business, and suddenly someone starts acting a bit oddly. Cue the finger pointing. Much like today's paranoia over that suspicious-looking vegetable in the fridge, the fear of witches stemmed from a lack of understanding. Illness, misfortune, and the occasional bad harvest were often blamed on witchcraft rather than, say, poor farming techniques or the common cold. Justice? More like just us. The legal standards of the time could be summed up as, "You're guilty if we say so." The American witch trials fundamentally exposed the flaws in English common law and deeply influenced the modern American justice system. The horrors of the trials spurred 4 major legal advancements. Banning spectral evidence. Courts previously allowed spectral evidence, claims that a victim was harmed by an invisible ghost or spirit. In late 1692, Governor William Phips prohibited its use, ensuring that convictions required solid, provable evidence. Let's dig a bit deeper than just stating, "Ghosts make terrible eyewitnesses." Thanks to the spectacular mismanagement of the witch trials, the U.S. eventually decided that proof beats imagination, albeit at a snail's pace. Fast forward to 1975, when the Federal Rules of Evidence, FRE, strutted onto the scene like a reform-minded superhero. These statutory codes dictate what evidence can make the cut in civil and criminal trials across federal courts. In short, they ensure that trials are fair, efficient, and based on something more reliable than a ghostly whisper. Right to legal counsel. The witch trials played a surprisingly pivotal role in shaping the right to legal counsel in U.S. court proceedings. During these trials, accused witches often found themselves without any semblance of legal representation, leading to convictions based on little more than hearsay and spectral evidence. This debacle eventually sparked a collective desire for a fairer judicial process. Fast forward to the Sixth Amendment of the U.S. Constitution, which guarantees the right to counsel in criminal cases. However, the Sixth Amendment did much more than simply invite an attorney to sit at the defendant's table. It laid the groundwork for a fair trial experience that's almost as essential as coffee on a Monday morning. It guarantees a speedy and public trial, ensuring that no one is left hanging indefinitely in legal limbo. Then there's the impartial jury clause, which calls for 12 unbiased peers from the very state and district where the alleged crime occurred, because nothing says justice quite like a jury that isn't stacked with your enemies. Let's not forget the notice of accusation, which mandates that the government must inform the defendant of the nature and cause of the charges, because finding out you're being accused of something is always more pleasant when it's delivered with a side of clarity. The Confrontation Clause gives defendants the right to face and cross-examine witnesses, ensuring that the prosecution can't just throw around accusations without accountability. Compulsory process allows defendants to subpoena witnesses to testify on their behalf, meaning they can actually bring in people who might say, no, they weren't at the witch hunt. They were home binge-watching their favorite show. And if a defendant can't afford an attorney, the court must appoint one, making sure that justice isn't just for those with deep pockets. Presumption of innocence. The witch trials had a rather uncanny impact on the presumption of innocence in U.S. law, transforming the judicial landscape faster than you can say, burn the witch. During these trials, the accused were often presumed guilty until proven innocent, a concept that worked out about as well as a flat tire on a road trip. The presumption of innocence is enshrined in the U.S. legal system primarily through the 14th Amendment, which guarantees due process and equal protection under the law. 8. This principle dates back to ancient Roman law, where it was articulated that a person is considered innocent until proven guilty, a concept that would eventually make its way into English common law. The principle of presumption of innocence in U.S. law was solidified in the landmark case of Coffin v. United States, 1895. In this case, the Supreme Court emphasized that the presumption of innocence is a fundamental right, asserting that the accused should be treated as innocent until proven guilty. Separation of church and state. The witch trials were a turbulent time when the lines between church and state were as blurred as a foggy night in Salem. During these trials, religious fervor drove the legal proceedings, with judges and juries often swayed more by scripture than by reason. This chaotic blend led to a realization that perhaps mixing holy water with judicial processes wasn't the best recipe for justice. Fast forward to the establishment of the First Amendment, which firmly enshrined the separation of church and state in U.S. law. 10. This principle was a response to the religious zealotry witnessed during the trials, where a simple accusation could lead to a trial by fire. The founders, likely remembering how easily things could go sideways when beliefs took precedence over evidence, aimed to ensure that the government wouldn't play favorites with faith. Today, we appreciate this separation, as it keeps our courtrooms free from the influence of any one religion, allowing for fair trials where evidence reigns supreme over exorcisms. So, while the witch trials might have seemed like a dark chapter in our history, they ultimately helped illuminate the path toward a more just and balanced legal system, one where you're judged by a jury of your peers, not your pastor. Witness testimony. And then came the Dober standard, which is like the bouncer at a scientific nightclub, ensuring that only valid, reliable, and relevant expert testimony makes it past the velvet rope. Established in Daubert versus Morel Dow Pharmaceuticals 11 and later enshrined in Federal Rule of Evidence 702, this legal rule turns judges into gatekeepers who keep junk science and wild speculation from crashing the party. When evaluating scientific testimony, judges consider 5 key factors. Is the theory testable, or is it just a whimsical idea? Has it survived peer review, or is it more of a secret recipe? What's the error rate? Are we talking a minor hiccup or a full-on disaster? Are there standards in place, or is it a free-for-all? And finally, does anyone in the scientific community actually accept this theory, or is it just a lonely voice in the wilderness? With these guidelines, the courtroom stays a bit more credible and a lot less chaotic. Side note, while the Dober standard applies in all federal courts and many state courts, a number of states still cling to the older Fry standard. This standard simply assesses whether a method is generally accepted within its specific field. The coexistence of these two differing standards across jurisdictions leads to inconsistencies in the American legal system. Critics point out that the Dober factors serve as guidelines rather than a strict checklist, which leaves room for subjective interpretation. This flexibility allows judges to admit or exclude evidence based on personal biases, creating potential disparities in how justice is served. Final thoughts. The witch trials of the colonial era may seem like a distant, eerie chapter in American history, but their legacy looms large over our legal system today, like a ghost in a courtroom. These trials, where accusations flew faster than a broomstick on Halloween, highlighted the dangers of a legal system that presumed guilt rather than innocence. As people realized that a mere whisper could lead to a witch hunt, pun intended, it became clear that safeguards were needed to protect the accused. Fast forward to today, and we have a robust legal framework that ensures individuals are presumed innocent until proven guilty. Thanks to the trials, we learned that due process isn't just a fancy legal term, it's a necessary shield against the chaos of mob mentality. So next time you find yourself in a courtroom, remember that behind all those legalese terms lies a historical lesson: the importance of fairness, due process, and perhaps a little caution before lighting the torches. After all, we've come a long way since the days of accusing neighbors of witchcraft. Now we just accuse them of stealing our parking spots. Thank you for joining me on this journey, and until next time, keep reading and stay caffeinated.